Could you all please ensure that your mobile phones are switched to silent? And councillors, please ensure that you speak directly into the microphone and make sure your card is pushed firmly into the console. Members of the public, I would like to say that as a committee, we understand that matters under consideration tonight can be emotive, but please refrain from any cheering, booing, barricade, etc. of people who you may not agree with. So I'd like to introduce the officers that have joined us this evening. So farthest away is Lewis Jones, the planning lawyer. Next to him is Elizabeth Sims, head of planning. Kaylee Taylor, planning officer, sorry Kaylee, and Louise Yandel, area team leader. So moving on to the matters for this evening. First, the minutes of the last meeting have been on the table in front of you for the last 30 minutes. Are you happy that I can sign them later as a true record?
Agreed.
Thank you very much. Amy, any apologies for absence or declarations of substitutes?
Thank you, Chairman. Apologies from Councillor Dennis Lee and Councillor Nabil Nazir.
Thank you. Any declarations of interest?
None before the meeting, Chairman.
Questions from the public?
None received, Chairman.
Questions from members?
None received.
Jolly good. So we take our usual look at performance against government targets. They are attached to the second update sheet, but I think Elizabeth or Louise? Louise is going to introduce them. Thank you.
Thank you, Chairman. So as the Chairman said, they're on the second update, which is the green pack on the yellow page at the rear. As you can see, in terms of speed on both major and non-major applications, the department is performing excellently. And with regards to quality in terms of the appeal decisions, we are also well below the 10% figure of allowed major appeals and the 10% figure of non-major appeals. Thank you, Chairman.
Thank you, Louise. So we move on to the main item for discussion this evening. Application for planning permission, reference WA/2018/0151, Longdean House, Hedgehog Lane, Hazelmere, GU27 2PH. This is a hybrid planning application for change of use, extension and alterations to office building to provide one dwelling, together with the erection of a detached garage, outline application with access and landscaping to be determined for the erection of up to 28 dwellings following demolition of 2 dwellings, glasshouses and outbuildings. And I would invite Kaylee, got the name right this time, to present this application. Thank you.
Thank you. The site is located to the southwest of Hedgehog Lane in Hazelmere. The site is located in the countryside beyond the Greenbelt. The majority of the site is located within the AONB and AGLV, with the northeastern corner of the site being within the AGLV only, as shown on the extracted policies map on the right. The aerial image on the left shows Longdean House, which sits on top of a hill, with gardens and fields surrounding it. Public footpath 35 runs across the north of the site, shown here. The land beyond this is the Sturt Farm site, which has been granted outline permission for 135 dwellings, with a reserved matters application currently undergoing consideration. Just here. The image on the right shows a closer aerial view of Longdean House, shown here. There is a lodge here and a pair of semi-detached dwellings here. There is a car park here, a swimming pool building here, and a tennis court here. The glass house and outbuildings can be seen here. The planning history for the site is set out in full in the agenda report. Members should note that there is currently an appeal pending for planning application WA 2016-1226. The Council refused this application under delegated powers in September 2016. This was subsequently appealed. Following a public inquiry, the planning inspector allowed the appeal in September 2017. However, the planning inspector misapplied the tilted balance and concluded that the benefits would not be significantly and demonstrably outweighed by the limited harm the proposal would cause to the AONB. The council challenged the inspector's decision. The planning inspectorate agreed that the decision was legally flawed and should be quashed. The appeal has been referred back to the planning inspectorate for redetermination with a proposed public inquiry in October. It is important for members to note that the inspector's decision was quashed due to his misapplication of the tilted balance rather than matters of planning judgment. As such, the conclusions reached by the inspector on the planning merits are a material consideration, which officers advise members should attach some limited weight to. Since the initial appeal decision, the Council has adopted the Local Plan, Part 1. The Council has produced a new land availability assessment and has undertaken the preferred options consultation for Local Plan, Part 2. The revised NPPF has also been published. The current application being considered tonight is identical to the application currently being considered by the planning inspector. The hybrid planning application seeks full permission for the change of use of Longdean House from offices to a single residential dwelling, alterations to the building and erection of a garage. Outline permission is sought for the demolition of buildings and the erection of 28 dwellings with layout, scale and appearance to be reserved. The applicant has split the proposal into 4 areas as annotated on this slide. The draft Waverley Borough Local Plan, Part 2, Sites Allocations and Development Management Policies has been published, but does not yet form part of the development plan. Area A of the application site is included as a site allocation for an estimated 25 dwellings, as shown as DS15 on this slide. As the document is progressing through public consultation, it can only be afforded limited weight at the present time. However, it does indicate that the Council considers that the site is suitable for new housing and is a material consideration. This slide shows Area A, the field to the northeastern part of the site, proposed for the siting of 25 dwellings as part of the outline permission. This slide shows a pair of semi-detached dwellings which would be demolished and replaced by 2 new dwellings as part of the outline application. This slide shows photographs of Longdean House, subject to the full permission part of this application, which will be presented in further detail later in this presentation. And this slide shows the glass house and outbuildings which would be replaced by a single dwelling as part of the outline permission. Returning to the full part of the application, this slide shows the existing and proposed south and west elevations of Longdean House. Here you can see the proposed 2-storey extension to be removed and the proposed porch. Here again, you can see the proposed 2-storey extension to be removed, and you can also see the proposed roof lantern. This slide shows the existing proposed northern and eastern elevations. The proposed extensions to be removed are here and here. You can see the proposed roof lantern here. And again, you can see the proposed extensions to be removed here and here, and the proposed porch just here. There is a garage and parking space proposed to the front of Longdean House. This can be seen on this slide. The matters of principal and technical opinion are the principle of development, prematurity, loss of agricultural land, loss of suitably located commercial land, housing land supply, housing mix, affordable housing. Members should note that 37% affordable housing is proposed, 7% above our policy requirement. This is an additional benefit that members should take into consideration. There's also the impact on heritage assets, impact on highway safety and parking provision, impact on the public right-of-way, refuse and recycling storage, air quality, land contamination, archaeological constraints, impact on trees and ancient woodland, flooding and drainage, infrastructure contributions, the effect on the SBAs, and biodiversity. The matters of judgment which members are asked to consider tonight are the location of the development. The site adjoins the settlement boundary of Hazelmere and is in close proximity to the town centre, which has a large number of services and public transport links. Impact on landscape character. It is considered that Area A would only result in moderate adverse impact on landscape character within Area A itself, and only slightly adverse impacts beyond the application area. This is considered to amount to limited harm. Areas B, C, and D would have no adverse impact on the AONB, and in these areas, the intrinsic character and beauty of the countryside would be preserved. Officers consider that the proposed development is not major development for the purposes of AONB development. The impact on visual amenity. With regards to the full part of the application, the alterations to Longdean House and the erection of a garage, officers consider that the development would have an appropriate scale, layout, and appearance. For the remainder of the proposal, the layout, scale, and appearance would be considered at the reserved matters stage. However, officers are satisfied that an appropriate design scheme could be achieved. Impact on residential amenity. Officers consider that there is sufficient distances to neighbouring occupiers. Standard of accommodation and amenity space and play space. Officers are satisfied that the scheme would provide a satisfactory level of accommodation and amenity space. Whilst play space has not been shown on submitted plans, officers are satisfied that this could be provided as part of the reserved matters stage. Officers considered that the identified benefits outweigh the limited harm to the landscape in Area A and the conflict with the development plan. As such, planning permission is recommended for approval. Please can I draw members' attention to the update sheets. The first explains that officers have reconsulted consultees regarding the recommended conditions following comments from the applicants. In light of the consultee comments, conditions 11, 14 and 31 have been removed from the recommendation. There's been one additional letter of objection relating to prematurity, site constraints, highways, and whether the development should be considered major development in the AONB. This has been summarised in the update sheet and the Council's response is provided. The second update sheet responds to minor typos that have been highlighted in the agenda report. Condition 3 has been amended to remove the word general to state that the housing mix shall be in accordance with the SHMA. An additional condition has been recommended to secure a scheme for the provision of electrical vehicle charging points. Moving to the recommendation, this would be the revised recommendations A and B as set out on page 2 of the second update sheet published today. Thank you, Chairman.
Thank you, Kaylee. This application is subject to public speaking, and I would invite First of all, the objector, Mike Barnes, to speak. Good evening, Mr. Barnes. I understand the procedure has been explained to you. You have 4 minutes from the time that you start speaking. Of course, yes. I think it's only water, though.
Good evening. I'm speaking on behalf of the Action Group representing the residents and users of the network of 5 roads leading to Hedgehog Lane, representing more than 250 signatories from 178 households who submitted a petition objecting to this development. Major concerns are focused on developing housing in an area of outstanding natural beauty, and County Highways Authority not addressing serious traffic issues relating to the only site access via the exceptionally dangerous blind corner junction at Hedgehog Lane, Courts Hill Road and Longdean Road. The stated objective for WBC is to secure sustainable development that improves the economic, social and environmental conditions in their area. New housing developments should meet these criteria. Surrey Hills confirmed the undeveloped nature of this part of Haslemere is important to its countryside setting and character. Our objective is to highlight the reversal of council policy involving development of site DS15 around Longdean House. All previous applications from 1980 have been refused. 2 appeals have been defended by WBC, the first upheld, the second scheduled for decision by Bristol Inspectorate on the 9th of October 2018. Our objections are based on this development is a major site and not a major one, as it comprises 10 or more dwellings. We appreciate that it is contentious as to what's major and minor, but for purposes that's major. This site is not a sustainable development because it is an area of outstanding natural beauty, it is an area of great landscape value, it falls outside the current Haslemere Town settlement boundary. Under the approved LPP1, paragraph 1330, exceptional circumstances have not been demonstrated nor proven to be in the public interest. Previous land availability assessments, LAA, judged all land around Longdean House to be unsuitable for development. An independent Atkins report dated May 2018 on sustainability, prepared for WBC, showed this site failed significantly in 12 of the 15 criteria. The remaining 3 were borderline. It was concluded to be less sustainable relative to other sites. County Highways Authority have treated traffic, access, safety and congestion on this small network of roads, effectively single lane due to parking and deliveries, as minor and not major. This network of roads leading to and from the site is known to be a major traffic risk and dangerous during key times daily. Dangers will increase at the 3 access points with the major roads A286 and B2131 should the proposed radical change at Longdean from offices to more than 25 dwellings plus a cycle route be allowed. Blind corners are on each of the roads leading to the dangerous junction with Hedgehog Lane, the sole entrance exit leading to and from this site. Pavements are inadequate, pedestrians cannot walk safely. No viable reasons have been given for changing previous rejections of this development, which is not being treated as major. Building of houses in AONB is being encouraged rather than discouraged. Sturt Farm is an exception, not a precedent. The judicial review to transfer more than 800 homes from Woking to WBC is awaited. This would impact on the WBC housing policy. Acting preemptively before the national government has clarified the impact of the revised MPPF on development in AONB. Adverse comments from Surrey Hills, CPRE, Haslemere Vision and the public have not been considered. There has been no constructive consultation with the public. In conclusion, this development is a major one within the AONB and AGL in a non-sustainable position. Benefits have not been identified as being allowed with the Council's objectives. The harm and conflict aspects are not limited. They are serious and permanent, so outweigh minor benefits. They conflict with the development plan, LPP1, is crucial and should not be set aside. Waverley are rejecting the pending High Court appeal if this application is granted. The public response to LPP2, our petition and High Court appeal have not been addressed. Waverley will be failing its duty of care to Haslemere residents if this application is approved. Waverley has allowed County Highways Authority to ignore the access, safety, traffic and congestion reports. An independent survey over 4 to 6 weeks should have been demanded to provide an accurate decision, not one created by software.
Could you sum up now, please, Mr. Barnes? Thank you. Thank you very much.
All right, thank you.
Now I'd invite the supporter, Ian Rhodes. Again, I understand the procedure's been explained to you. Thank you. Jolly good.
Good evening, Chairman and members of the committee. Thank you for allowing us to speak in support of the proposals for Longdean House. Your officers have been most helpful in setting out the details of the planning history of the site, so I won't bother to repeat those. But to say this application was submitted following Waverley's decision to challenge the earlier identical planning consent on the scheme, which was granted at appeal. As explained in the report, this challenge was made purely on technical grounds and did not seek to dispute the inspector's judgment regarding the only substantive grounds for the previous refusal. In resubmitting these proposals, our approach has been to cooperate with Waverley to deliver the development, which has therefore, in all practical respects, already been found acceptable. Since the challenge, the Council has published its Local Plan Part 2, which includes proposals to allocate the majority of the site, Area A, for housing. This submission therefore provides the opportunity for the development to be considered by the Council in accordance with its emerging local plan, thereby avoiding any unnecessary further waste of resources, whilst potentially delivering the site at an earlier date. The scheme provides a net gain of 27 dwellings, 25 of which are situated on land within the proposed housing allocation, the remainder being on previously developed brownfield sites. The scheme offers as close as possible to 40% affordable homes in an area where there is already significant unmet demand. This generous provision would weigh significantly in favour of the application, especially since the applicant has not sought any reduction despite the 30% policy contained within the Local Plan Part 1. Being predominantly within the ANOB, the impact of the development on the wider landscape is, of course, of key importance. However, in allocating the land within the Draft Local Plan Part 2, the Council recognise that the topography of the site and the mature tree screen which surrounds it minimise any wider impact. This concurs with both the Inspector's report and the Council's expert evidence at the inquiry, which confirmed that there was no adverse impact on neighbouring homes. The Inspector also confirmed that the proposals for areas B, C and D, which primarily alter or replace existing built form, would serve to preserve the character of the ANOB. The means of access to the site has now been considered by Surrey Highways on 2 separate occasions and found to be acceptable. The cessation of the existing office use at Longdean House means that there will be no net increase in the level of traffic movements already associated with the site. Looking forward, residents will benefit from easy access to the station and town centre with walking times of approximately 6 and 12 minutes respectively. Concern has been raised regarding the possible cumulative impact on highway safety in the event that any adjacent sites were to be delivered. However, this is a matter for any future application to address and resolve. It remains that this scheme would not result in any net increase in traffic movements and would therefore have no additional impact on the surrounding road network. The application includes a package of financial contributions agreed with Waverley and Surrey totalling over £350,000 to fund local schools, leisure and sports facilities. The application has generated very little objection and the Town Council have not raised any issues. Overall, these proposals will deliver an appreciable number of homes, including 10 new affordable units, in an area which is highly constrained in environmental terms, without any significant harm to the character and appearance of the ANOB, or any increase in traffic. It is consistent with your adopted Local Plan Part 1 and the emerging Part 2. We therefore ask members to support the officer's recommendation for approval.
Thank you, Mr. Rhodes. Members. Councillor Mulliner.
Thank you very much, Chairman. If I may start off with a gentle comment to the officers that it was good to see the appeal decision enclosed with an update tonight, but in future could I suggest they go out with the original papers. Secondly, a comment was made that the appeal inspector's views on planning matters should be given weight, which I entirely agree, but one must take into account as well that his error was to apply the tilted balance and not the untilted balance. And simply as a matter of logic, we cannot tell whether he would have found the harm which he agreed existed would have outweighed the benefits on an untilted basis. I think our job is to consider whether this application, which is identical with the one which was refused by officers with local members' support 2 years ago, is now subject to different considerations. The test on page 32 is the traditional one. Have changes occurred since the last application to make this application acceptable in its own right? And with no changes whatsoever to the application, one is obviously looking for other factors. And I can think of two which work in favour of supporting the previous decision. The first is, of course, that we have Local Plan Part 1 and the 5-year housing land supply is now not in doubt. That clearly played a significant part in the inspector's thinking, and it led clearly to his belief that the benefits of allowing 27 extra houses outweighed the harm to the AONB. However, we are looking at it on an untilted basis. And the second factor which has occurred, which makes this application unnecessary in my submission, is what has happened in Haslemere over the last 3 years. I have been keeping a track of all the applications and permissions, and Haslemere, like other places, has become something of a windfall centre. Over the past 3 years, undoubtedly stimulated by the change in the General Permitted Development Order regime, which permits changes of use from office and retail to residential, over 130 permissions have been granted, an average of 45 per annum. I would add that the applicant very reasonably made the point that this application has a more than usually, or has a generous allocation of affordable housing. I would make the point in response that although there are understandable concerns about windfall developments involving changes of use, in fact these are the ones which develop the small units which are genuinely affordable. An expensive house, whether sold at full value or 80% of full value, often turns out to be less than affordable. So the situation that causes me to wonder, has anything changed to justify changing the previous decision, is this application any more necessary now than it was then? I appreciate the point has been made that the Local Plan Part 2 is in draft form, but I would take quite firm issue with the allegation or the statement that the Council has decided that DS15 is a suitable site. With all due respect to the planning policy team, it is their proposal. It has not yet been through members' scrutiny and challenge, and I can say, from my own knowledge, that all the applications in the Haslemere area which seek to build in the AONB will be subject to robust challenge. So I don't think it's fair to say the Council has decided anything. Members in due course will decide whether to accept Local Plan Part 2, and in the overview and scrutiny process will be able to make changes or to recommend that changes are made. So I think the true situation we face is again to answer the question, are there any changes which justify a change of view? In my opinion, Chairman, there are not, and I shall not be supporting the officer's recommendation. Thank you.
Thank you, Councillor Mullen. The Councillor follows.
Thank you, Chair. First off, I agree with most of the comments that Councillor Muller put forward there, particularly about receipt of the actual inspector's report. I didn't actually get time to read that this evening before coming into the chamber, and that, I think, was material to a lot of the discussion. I just wanted to clarify a couple of points. My understanding from the officer's report, the MPPF and AONB policy requires that developments like this need to still demonstrate those exceptional circumstances that were referred to by the objector. The Surrey Hills AONB officer's comments also seem to back up that. So our officer saying that this application does or does not need to demonstrate exceptional circumstances, and if they are, is this 7% affordable housing uplift, is that the only one? Because I can't see any others. And the other very small comment to if you could elaborate on, could you just, in your own words, describe what the criteria are between major and minor developments in this case? Because it does seem to be subjective, and I would just like to understand what the officer's opinion is on this. Thank you.
Thank you, officers.
Thank you. Firstly, if I answer your second point first, because it leads on to the first point, it is a matter of planning judgment to determine whether the site is or is not major development in the AONB. Established decisions on this matter refer to the sort of landscape impact and the settlement as a whole that it would be attached to. So, for example, a large attachment to a small village is more likely to be considered major than a small attachment to a large town. In this regard, officers have had regard to the inspector's view on that, and we have concluded that the proposal is not major development in the AONB. And following on from that, as we have considered that it's not major development, you do not need to pass the test of exceptional circumstances. What you do still need to do is assess the impact on the landscape, which you would do for both major and non-major development in the AONB. Thank you.
Do you wish to come back? No? Okay, thank you. Councillor Goodridge.
Thank you, Mr. Chairman. Clearly there have been changes since the officers refused this in 2016, a similar application. If I could just deal with matters that have been raised for highways first. Clearly on highways, the Surrey County Council as the highway authority are in no way objecting, and indeed when the officers refused the application in 2016, we presumably had similar advice from the Surrey County Council because we didn't raise an objection to the 16 application on highway grounds. I would have thought, therefore, that any refusal on highway grounds is a non-starter and would cause us no end of grief at any planning appeal and money. Then the next major point, it seems to me, is the question as to whether this is a major development in the ANOB. And whatever the inspector may have said, what he did say was, in his judgment, this was not a major application in the ANOB. And as I understand it, therefore, we are going to have some difficulty in saying it is a major matter, which therefore requires exceptions to arise. And I think that is a change to the situation that we had in 2016, which puts us in a more difficult situation had this appeal not got as far as it had earlier in last year. I also note, and it is something which I take notice of, is the Town Council are not raising any objections. And that seems to me an important issue. I don't know whether they objected to the 2016 application, because this was decided by officers and didn't come to committee, certainly didn't come to this committee. But I note, that the Town Council are not objecting. The other thing is the alterations to Longdean House do seem to me to be actually an improvement to the building. I mean, there clearly have been, it's not a listed building as I understand, but they have put on some fairly mundane extensions in the past, with greatest respect to whoever did them. And it does seem to me that the extensions and alterations that are now being made to Longdean House are an improvement and certainly not detrimental. And therefore, subject to what anybody else may be saying, I am minded to go along with the officer's recommendation at this stage. Thank you.
Thank you. Louise, did you wish to comment?
Thank you, Chairman. With regards to your first point, which is in relation to the highways issues, officers agree with your opinion on that. It would be unreasonable to introduce new grounds of objection when those matters have already been agreed. In relation to the major, whether it's major development in the AONB, our advice is that you should have regard to the inspector's conclusions on this issue. And with regards to the Town Council comments on the 2016 application. I'm afraid their comments were slightly ambiguous at the time. They said that they didn't want to make a comment, but they would want to make a representation at the Joint Planning Committee meeting. As it was done under delegated, we don't know what they would have said at that meeting, but they certainly didn't say whether they objected or didn't object at that time. Thank you.
Thank you. Councillor Adams.
Thank you, Chairman. Just a few points. How many employees are there at Longdean House at the moment?
Unfortunately, I don't know the answer to that question. The planning, the conclusions in the officer's report would be, as planning conclusions are always based on the lawful use of that site. So, for example, in relation to highways and vehicle movements, they would be based on the total occupancy of that building, regardless or not as to whether it's only partially occupied. But unfortunately, I can't give you the exact number because I don't know it. Thank you.
Okay. I don't have a problem with B, C and D. What is the density of Area A in respect of the housing? I did look through the report. It's not in there anywhere that I could see.
So we're just going to find that information for you.
Okay. Okay, well, another question is, bearing in mind that the inspectorate is still looking at the original 2000s, are we not being premature in looking into this application? Seems really strange that when we're waiting for something to come through in a couple of months' time, that we're being asked to revisit it at this stage.
Louise.
Firstly, in relation to your density query, there are 18.5 dwellings per hectare. In answer to your second query, this application has been submitted to us. It is a valid application. It is perfectly reasonable and expected that we should make a decision this evening. Officers do not think it is premature. The applicants have indicated that should this application be approved this evening, then they may wish to withdraw the appeal. Alternatively, if it is refused this evening, then they would continue with the appeal to get a determination by the inspector. But there's no reason why members can't come to a conclusion on their own judgment this evening.
Okay.
Thank you.
Finally, the last one. I agree with Councillor Mulliner over the 5-year supply. We now have a 5-year supply, so why do we need to build this in the AMB at all?
Whilst we have a 5-year housing land supply at the moment, the housing allocation for Hazelmere set out in the local plan is set out as a minimum of 990 dwellings. So it's not sort of a maximum figure. And in addition, given the constraints of the borough, it is expected that some development will need to come forward on sites such as this one. And so it wouldn't be unreasonable to determine the application on that basis. Thank you.
Thank you. Thank you.
Thank you. Councillor Townsend.
Thank you, Chairman. I've got a question on the appropriate assessment. I notice in the appeal that the inspector at point 49 said that there was no mitigation had been requested in this case, as there is an over-provision of mitigation within measures for the adjoining Sturt Farm scheme. However, I know we're giving this limited weight. I would expect that the appropriate assessment would include the mitigation methods or the mitigation, outline the mitigation, even if it is in another application on Sturt Farm. And I just am querying how a decision can be made when the mitigation has been recognised that there is a need for mitigation. It's saying there has been an over-provision, but there is no mitigation outlined in the appropriate assessment. Perhaps officers could reply to that.
Louise.
Thank you. The Council's evidence at that point was that no mitigation was required due to the size of the scheme and the availability of alternate recreation facilities. With regards to this application, we have performed an appropriate assessment. The site is within the 5-kilometre buffer zone of the Wilden Heaths, where we assume that there could be a likely significant effect, and we have performed that appropriate assessment, come to the conclusion that due to the availability of alternative recreational facilities, there would be no harm, and that has been looked at and confirmed by Natural England that they are satisfied with that approach. So we are satisfied as officers that there wouldn't be an impact on the special protection area. Thank you.
Councillor Coburn.
Thank you, Chairman. Not for the first time in this committee or indeed in any of the planning committees, I actually think we're between a rock and a hard place on this one. We have a planning decision, and on the planning matters, it is absolutely crystal clear. There was one sole remaining reason for refusal, and the inspector dismissed that quite clearly, and says that, his attitude to our remaining refusal at the time, that it would cause harm, he dismissed. So we have one decision on the main bit. We have a decision that 38 is perfectly acceptable, so what's on this site is even more acceptable. And the third thing, so it's not major as far as he's concerned. And he concluded, absolutely, he says, I conclude that due to the screening, there will be a moderate adverse impact on the landscape character within the tightly drawn area A, with only slight adverse impacts beyond the red line application area. I find it very difficult to understand how we could possibly argue against that. I know that there's going to be another hearing, but as we were told earlier, that's much more on the technical, the way that the housing trajectory and all of that was assessed. It wasn't on the main planning issues. And I would have thought, reading the inspector's report, on the three main planning issues, we have guidance. We have absolute decisions. The inspector is very, very clear. Regardless of what I personally think about this scheme, I think most of us, accept B, C and D without much problem, and do have issues perhaps with A. I really don't feel we have any grounds. I think we would be unreasonable given how firm the inspector is on the three key issues that members have raised. And I think we would have to be very, very careful before we make a rash decision on this and letting our hearts rule our heads a little bit.
Thank you. Councillor Hyman.
Thank you, Chairman. I could not possibly disagree more with Councillor Coburn, unfortunately. I agree with what Councillor Mulliner was saying in terms of the test, which was have any changes occurred, and I'd say obviously not to the application. It's the same, we're told, but certainly the overriding law has been clarified in a ruling. That ruling says that we have to have an assessment of the mitigation, and we haven't got it, and so we can't grant consent. It's that simple. If I turn you to, if you would, the bottom of page 57 of your officer report, members, it says, the very last sentence says, officers are satisfied that the proposed development would constitute sustainable development. Now, I'm hoping that officers will also, though, confirm that paragraph 177 of the revised 2018 National Planning Policy Framework, NPPF, states, and I'll quote if I may, Chairman, the presumption in favour of sustainable development does not apply where development requiring appropriate assessment because of its potential impact on a habitat site is being planned or determined. And I have mentioned this before in the Chamber, Chairman, as you probably recall, but this is not considered sustainable development, and the presumption does not apply because there's an AA. I mean, that is absolutely straightforward. I haven't made it up. It's there in the NPPF. So where at the bottom of page 58 officers are telling us that it is sustainable development, that's completely the wrong approach. We know for a fact, in accordance with the National Planning Policy Framework and the fact there's a requirement for an appropriate assessment, we know that it's not sustainable development. So I'm glad that somebody else is reading the papers on this subject. I was going to quote from paragraph 49 myself, where the inspector had said that he was that the mitigation was coming from the Sturt Farm application. Now, whether or not we didn't get a response from officers that clarified actually whether, if this is going forward to an appeal or being challenged at any point, whether Waverley is saying, whether we here and the developer here are saying that the mitigation from Sturt Farm is being used, or whether we're going to completely ignore the in-combination effect. Because obviously the law does require we consider in-combination effects, and this in combination with all the other developments. 2 developments of 27 houses is the same as a development of 54 houses, isn't it? And so you can't say one requires appropriate assessment, the other 2 don't. So we don't have an assessment of mitigation. We know from the Sweetman people over wind determination, the ruling, that there must be no lacunae, there must be no gaps, and the appropriate assessment, so-called appropriate assessment we've got in front of us, members, has no bird numbers in there, so we don't know the population trends, which is vital to make it to the appropriate assessment. The law says so. There's no in-combination assessment. There's no assessment of the efficacy of the mitigation. We cannot possibly know whether the mitigation fully mitigates this or is having the opposite effect to intended without that. And the statutory instruments, Circular 06/2005, paragraphs 20 and 21, make it absolutely clear in the circumstances, Chairman, we must refuse consent. And so I will be complying with the law. I have no desire to deprive the people of Hazelmere or Godalming, Milford, other areas of the protection that they have from overdevelopment that's in law due to our little neighbours. Thank you, Chairman. I'll be voting against this.
Thank you, Councillor Hyman. Officers, I expect you would like to respond to some of those points.
Thank you. Just want to make the one point really that the appropriate assessment took into account the site circumstances, and the conclusion of the appropriate assessment was that no site-specific mitigation was required due to the availability of alternate recreational facilities. So we do not even need to consider in this particular application whether the mitigation is acceptable, because there is no mitigation. However, we are satisfied that mitigation such as SANGs can be appropriate to mitigate for the impact on the SPA. In this particular instance, as we've said before, the appropriate assessment has been performed. The expert body, Natural England, have confirmed that they agree with our conclusions of the appropriate assessment, and there is no evidence to suggest that we should disagree with that expert body. Thank you.
Councillor Hyman, did you want to come back briefly, please?
Thank you, Chairman. I'd just like to point out that the ruling of the 12th of April, the Sweetman People Over Winds, C323/17, made it quite clear when in applying that decision here that the advice that we're getting from officers, Waverley's position, which is unchanged, they say we don't need any assessment, or we don't need any mitigation in this case. There was no in-combination effect, which is completely contrary to the point of the law. They decided that Natural England, the recognised expert, and this council's approach was incorrect. And now what we have to look at is, do we have mitigation for what is an admitted effect? Do we have that in an assessment?
I'm sure the officers understand your point, Councillor Hyman.
I'm hoping other members will. Thank you.
Elizabeth.
Chairman, I do understand entirely what Councillor Hyman, the point you are seeking to make, but just to support what Louisa said already, but perhaps just saying it in a slightly different way, we recognise entirely that the Sweetman judgment required us to change our approach, and we did that, and we did it very quickly, and we've been through that discussion many times in this chamber since that point in time, and that is why we are now undertaking appropriate assessment in order to give advice to you as to whether or not the effect on the SPAs is acceptable. That approach is in place. We are consulting Natural England, and that is exactly what we have done in relation to this application. But the point about mitigation is where Natural England confirmed that there is a likely significant effect, it needs to be mitigated. And the mitigation can only be taken into account at the appropriate assessment stage. The important point here is the mitigation is not required because there is no likely significant effect. And that has all been articulated through this appropriate assessment process and confirmed by Natural England that it passes appropriate assessment without the need for mitigation due to the appropriate alternative recreational opportunities in the area, which themselves negate the impact of the development on the SPA. There are already alternative recreational opportunities such that additional mitigation with this development is not required. So the test has been followed clearly and properly. Natural England are fully supportive of the approach we are applying, and the advice to you is that you can be satisfied that there's no undue effect on the special protection area. And Chairman, if I could just pick up on another concern of Councillor Hyman, you did say there seemed to be a tension between us concluding that as officers we found this to be sustainable development, which you did feel meant that we seem to be considering that we're applying the presumption in favour of sustainable development. But with the greatest respect, those are two, they sound like they're the same thing, but they're two different concepts, in that the presumption in favour of development is otherwise known as the tilted balance. It's where the planning authority is required to weigh significantly in favour of the development because certain circumstances exist, and we're more familiar with the fact that, well, we don't have a 5-year housing land supply, we need to apply the tilted balance. Sustainable development is in itself development which you come to the conclusion is development which can be supported because it meets the tests of the NPPF. So we regard this as sustainable development for the reasons that we're concluding in our report, but we are not applying the tilted balance because it's not appropriate in this instance for the reasons we've given. That, of course, is what the inspector did and how he erred. So we're not following what he did because clearly we challenged that decision. So we're not applying the tilted balance, but we do regard this in the round as sustainable development. And I do hope that's helpful, Chairman. Thank you very much.
Thank you, Elizabeth. Lewis, did you wish to add to that?
Thank you, Chairman. I thought it would just be useful just to remind members of a point that Lisa Bush QC made during her training session a month or two ago, but it's just on the role of Natural England. And it's just to confirm that as the local planning authority, we are entitled to place considerable weight on the opinion of Natural England, as they are the expert national agency with responsibility for oversight of nature conservation. And the case law on the issue does stress that we ought to do so unless we have good reason not to. And as we've just discussed, I think officers' view is that there are no good reasons to depart from Natural England's advice. I think it's also just helpful to point out that their advice, they are accepting of our approach post-Sweetman. They have approved our appropriate assessment template, and specifically they have signed off on this appropriate assessment as well. So that's all I had to say, but thank you, Chairman.
Thank you, Lewis. Councillor Mulliner, did you wish to make a new point?
Well, if I could crave your indulgence, 4 minutes is remarkably restrictive when it's a complicated matter. But I just wanted to politely challenge Councillor Coburn's view of the appeal. This is a quashed appeal, and I think it's very clear from the reading of it that the inspector's error played a major part in his overall view. And therefore, to me, it is important that this matter be reheard in front of someone who will not make the same mistake. It's all a matter of judgment. The first sentence of the reason for refusal is a perfectly adequate reason. That reads, the proposal as a result of the urbanising impact and harm to the landscape character would cause material harm to the intrinsic character, beauty and openness of the countryside beyond the green belt, area of outstanding natural beauty and area of landscape value. Full stop. It would have been good to have had the major application, exceptional purpose and exceptional reasons additional, but we don't need it. We have a perfectly good reason for taking the view that on balance, on the untilted balance, the harm is not outweighed by the benefits. The inspector, I'm afraid, got it wrong, and that is why I think the right thing to do is to refuse this application on effectively the same grounds as before and leave it to the new inspector. I would point out also that judgment comes into whether screening is actually effective. Unlike the inspector, I live in Hazelmere and have done for many years, and in winter the trees are far less effective screens than they are during the summer, when he did his own visit. So I think a fresh inspector could easily reach a decision which supports the officer's view in 2016, and I would like us to have that chance to get that decision confirmed. Thank you.
Thank you. Councillor Band.
Thank you, Chairman. Well, I've got considerable sympathy with the concerns expressed by those objecting to this application. But on the other hand, I have to say I agree with the comments made by Councillor Goodridge and Councillor Coburn. I find it extremely difficult, both in terms of the perceived impact of this development on the AONB as expressed by the inspector, and the issue of highways and the comments made by, highways. I find it extremely difficult to actually find grounds which I feel could be sustainable on appeal. And as Councillor Coburn, I think, very eloquently said, we're in a rock and a hard place. I really do find it extremely difficult in this circumstance to see where we can actually find grounds which will really sustain, as I said, on appeal. And so at the moment, I must say, I am inclined to reluctantly, I would say very reluctantly, to go along with the officer's recommendation.
Thank you. Councillor Inchbold.
Thank you, Chairman. Officers tell us that this is not a major application, but I have to say I think it's a pretty big minor one. It does intrude into the AONB. I take Councillor Mulliner's point that during the winter the trees provide very little in the way of screening, and anyway I don't think that the mere fact that there is screening around it is sufficient justification for sacrificing land within the AONB. It is inevitably going to be perceived as just an extension to Sturt Farm, and that on its alone, I think, mitigates against it. So I will be voting against the recommendation. Thank you.
Thank you. Councillor Follows, you wish to make a new point?
Can I just quickly ask, it does appear that as this appeal is in October, we're not talking about a very long time. So two very short questions. One, is there a particular rush that this can't wait until October? And also, are there consequences financially for the borough if we do reject this and let it go to appeal, or are these costs that have already been incurred that we can't avoid anyway?
Louise.
In relation to the costs question, of course, letting the appeal run when you think the development might be, well, is acceptable, then the council has the costs involved in defending the appeal. There are potential cost risks if we do not show that we have taken into consideration the previous conclusions by the inspector. Apologies, I've forgotten what your first question was.
Why is there a particular rush to get this in? Because I think several members have mentioned that this has come in despite the fact this is coming in October, and I think, is there a reason why that's the case?
We have an agreed extension of time until this week with the applicants, and so if we let it run over that time, then once the application is 26 weeks old, they can apply for their feedback. And of course, local planning authorities are meant to determine applications with either the statutory timescales or the timescales as agreed by the applicant, and yeah, so that that's what we're bound by. Thank you.
Thank you, Councillor Denis.
Thank you. I'll be very brief because most of the points have been covered. Can we just go back to the slide with the photographs? That's it there. I think when we've had a discussion about damage to the countryside, I just kept on thinking back to those 3 photographs, and I think that said it all for me. So I am concerned, but I won't repeat all the comments some of my colleagues have made, as I'll determine it myself. But just one positive, if I may, to the officers. During the report where you've shown the either the condition number or the informative, where it's against somebody's statutory response, was really, really useful. I raised it only a week or so ago. Delighted it was in this report. It made it far easier to tie all the bits in with the report. So it was just a thank you as well. Thank you, Chair.
Thank you. Councillor Byam.
Thank you, Chairman. Well, it's a very interesting and difficult problem here. Councillor Lynchball, we just brought up the point about Sturt Farm, and I was going to raise my hand earlier to ask. We haven't, I don't think, and anywhere shown in any detail exactly how Sturt Farm relates to this particular property. I'm trying to get, we obviously haven't had a site visit, but we did do site visits to Sturt Farm. I've got an idea in my mind, but I haven't got an absolutely clear understanding of its relationship with this.
It's the development shown along to the north of Site A. That's Sturt Farm.
That is
leads on down. Yeah. Right then, members, we'll move to the recommendation, the revised recommendation, which is a very long-winded one, but recommendation A is that, subject to the consideration of any further representations by the 22nd of August 2018 that raise further material consideration that have not yet been considered, and subject to a Section 106 agreement to secure contributions towards education, recycling provision, play and pitch improvements, off-site environmental improvements, SUDS and open space management, maintenance and conditions 1 to 10 inclusive, 12, 13, 15 to 22 inclusive, 24 to 30 inclusive and 32 to 42 inclusive in the agenda report, and amended condition 23 and additional condition 43 on the update sheet published on the 8th of August 2018, as well as informatives 1 to 15 in the agenda report and additional informative 16 on the update sheet, permission be granted. Can I have all those in favour, please? And those against? Thank you. So that application is refused permission. So we don't have to worry about recommendation B. Thank you, members. No? Oh, sorry, of course, yes. Yes, sorry. I need a proposer and seconder for the refusal. Thank you. Councillor Mulliner.
May I suggest, Chairman, we use the previous refusal shorn of its reference to...
So could you propose that we refuse this first of all, please, and have a seconder?
Yes.
And Councillor Inchbold, you'd like to second? Right, so Councillor Mulliner, I'll come back to you for the reasons for the refusal.
I would use the first sentence of the reason given for the 2016 refusal and delete the second sentence following officers' advice that it's not treated as a major one, and then continue with, this would be contrary to policies SP1, RE1 and RE3, the Local Plan Part 1, Strategic Policies and Sites 2016. Any advice from officers as to the wisdom of that will be appreciated, but that would seem to be the obvious reason.
Louise?
Thank you, Chairman. Yes, that sounds fine to me, with the exception of because it was the draft pre-submission local plan, it was dated 2016, so that should be changed to 2018. And also, we should also include the relevant paragraphs of the NPPF. I'm not up to speed with the exact paragraphs in the new NPPF yet, so I would recommend that you allow officers to insert those prior to issuing the decision.
Certainly, I'm sure we can. Yes. So, Councillor Hyman.
Paragraph 174A, footnote 56. Thank you, Chairman.
Thank you, Councillor Hyman.
Which refers to Circular 06/2005.
Thank you. So, members, the revised recommendation. Sorry, Councillor Townsend.
Sorry, is there anything that can be added about the impact on the mitigation or the impact on the SPA at all?
Louise?
Thank you.
In relation to the impact on the SPA, I would not recommend adding a reason for refusal on this. Firstly, Natural England have confirmed that they are satisfied with the proposal and that it wouldn't have an impact on the SPA. And then secondly, that didn't form a reason for refusal under the refuse scheme that is at appeal at the moment. So it would be unreasonable to introduce a new reason for refusal. However, what I would also recommend is that reasons 1 and 2 in recommendation B, which relate to the provision of affordable housing in the absence of the legal agreement, and the infrastructure contributions, that both of those are added to your decision this evening. Thank you.
Thank you. So, members, the revised recommendation proposed by Councillor Mulliner, seconded by Councillor Inchbold, for the reasons that we have just heard, that this application be refused planning permission. All those in favour, please. And those against?
5, Chairman?
Any abstentions?
No.
Thank you. So that recommendation is carried. So a little bit of deja vu. Thank you, members, and see you in a couple of weeks' time. Thank you.
5 days' time.
See you Monday. What's today, Monday?
The people